Good morning, good morning, good morning, everyone. Another merry, stupid o'clock to one and all. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels, and we're going back to that horrific world known as the JRC. Now, before we get going this morning, a few disclaimers. First of all, for the document we are reading today, you will, of course, find a link in the description, as well as other pertinent links to the Stop the Shocks campaign, including the two most important: one, to the templates, sign your name, click on your senator, help stop improper restraint. Also, we have the change.org Shut the Judge Rotenberg Center Down petition, because let's face it, these are real slippery bastards who've been getting away with this since the first death all the way back in 1986, taking their name from the very judge that has let them continue this horrible practice with impunity. Now, folks, on top of that, when we talk about the JRC, you are going to hear vivid descriptions of, as well as see video surveillance footage clips of people with disabilities being tortured and abused. If you have young ones present, please use your headphones. Also, folks, it is stupid o'clock in the morning. So, if I mangle any words horribly, my apologies in advance. So, back to where we left off yesterday, folks. It's called the Description and Purpose of the Report. For the purposes of not ranting about this particular judge and his views, I will try to keep it short this morning. The Description and Purpose of Report. The catalyst for this report was a very serious incident that occurred at JRC on August 26, 2007. This was a few years after the Andre McCullen events, during which two JRC students received a significant number of inappropriate GED applications. All applications of the GED are inappropriate, just in case you're wondering, Judge. This incident was the result of a hoax perpetrated by a prior JRC student who had eloped from JRC while on a trip to New York State. Immediately after the incident, state agencies were notified of what had occurred, and investigations were initiated and completed by them as well as by JRC. So you're going to trust an internal investigation from people who like to torture people. Okay, Judge Karen. After these investigations were complete, and after changes in policies and procedures were implemented at JRC, I doubt it. Yeah, but they changed. No, they didn't. I have Jennifer Masemba's testimony to tell me that. But moving on. Dr. Matthew Israel, then executive director of JRC, was indicted by a special grand jury in Norfolk County on charges of accessory after the fact and misleading an investigator or a witness in May 2011. They blacked out something. Wonder what that could be. We can't let that, awful news about what the JRC's been up to behind closed doors can't get out, can we, Judge? At Dr. Israel's arraignment on May 25, 2011, he entered into a sentencing agreement for pretrial probation, which required Dr. Israel to resign from his position as executive director and prohibited him from working for JRC or being on its board for 5 years. Oh, wow, 5 years. The dude should be in jail. God. The Attorney General for the Commonwealth of Massachusetts. Wait, I'm going to stop a minute. I want to know how this did not, immediately make Massachusetts look further into the JRC. Like, why did they just say, well, they changed and he stepped down, so all well that ends well. No. This should have triggered further investigation into the school. But since you folks don't seem to either A, want to do your jobs, or B, like that money that the JRC is using to line your pockets. Moving on. The Attorney General for the Commonwealth of Massachusetts, AGO, and the JRC's Board of Directors, the board, then entered into a deferred prosecution agreement whereby independent monitor would be appointed to review and assess safety at JRC in connection with the August 26, 2007 incident in order to ensure that a similar event would not reoccur. I want to know how a judge can observe the sick shit that goes on there and not immediately call for a full-scale investigation into this place. I'm just saying. Appointment of Judge Isaac Bernstein, retired, as monitor. On May 25, 2011, the Honorable Isaac Bernstein of counsel of the firm of Kajko, Wiseman, and Kolonsky and Stein, LLP, formerly Rubin, Wiseman, Kolosonti, Kajko, and Stein, LLP, was retained to act as an independent monitor. In summary, the agreement provided for Dr. Israel to resign from his position with JRC and refrain from working for JRC, except in a limited consultation capacity until December the 31st, 2011. Dr. Israel may act as a consultant to JRC at the request of a student's clinician and on approval of the monitor, Judge Bernstein. As to the scope of the investigation, the deferred prosecution agreement states as follows. Oh God. The monitor shall conduct an evaluation and review of the incident that occurred at JRC on August 26, 2007. The monitor may review any JRC policy or procedure that he believes contributed to the occurrence of the August 26, 2007 incident, which may include, but is not limited to, JRC policies on hiring, training, supervision, and video monitoring, the operation and management of JRC, and the composition of the Human Rights Committee. For fuck's sake, they have a Human Rights Committee there? Am I reading that right? My God, what kind of messed up, skewed idea of human rights do they have to let this continue? The monitor may also review at JRC any information he believes necessary to evaluate whether JRC has instituted sufficient measures to prevent a similar incident from occurring. I have one. Get rid of the damn devices, stop the food contingent programs, and stop the behavior lessons. I mean, that should solve the problem, I would think. Including but not limited to current JRC policies and procedures, the present operation and management of JRC, and the current composition of Human Rights Committee. The review and evaluation shall not include any review of the efficacy of adversives or any other treatment provided by the JRC. Oh, of course not. Why would Massachusetts give a damn enough to actually look to take care of its disabled constituents? Oh no, we can't be bothered to figure out whether or not they're being tortured and starved to death and deprived of sleep. Oh no, that's beyond the scope. Jesus. The monitor shall complete the evaluation and issue a report which shall include, but not be limited to, a determination of whether JRC instituted sufficient measures to prevent a similar incident from reoccurring. If monitor concludes that the sufficient measures do not exist, the report shall recommend specific measures JRC should institute to prevent a similar incident from recurring. Or you can do the fucking right thing, Massachusetts, and get rid of this place. Oh, but we can't expect you to look after your disabled folks. We're not human, right? JRC is solely responsible for the costs associated with Judge Bernstein's services, as well as the services of other staff at his law firm who work on the investigation. Upon receipt of the monitor's report and recommendations, the JRC board will have 1 month to vote on whether to adopt the recommendations in the monitor's report. You're giving them a choice? Let me. So, this incident occurred, and you people give this place so much damn slack. They get to decide whether to implement a judge's recommendations? Really? My God, they just get away with everything, don't they? Subsequent to deferred prosecution agreement on June 28, 2011, JRC, the AGO, and Judge Bernstein entered into a plea agreement which set out the terms of payment by JRC to Judge Bernstein's law firm, as well as the scope of the monitor's duties and provisions for full cooperation of the JRC's board of directors in the investigation. Oh, well, that explains it. There we go. Money. Why am I not surprised? The fee agreement tracks the deferred prosecution agreement with respect to the scope of the investigation by and JRC's obligation to cooperate with the monitor. Why would the monitor say anything other than the bare minimum when they're getting paid by the place? Just saying. After the report is issued and submitted to both the AGO and JRC, the board will have 1 month to vote on whether to implement the changes recommended by the monitor. Within 3 days of such vote, the board will inform the AGO in writing of which measures, if any, it did not approve, and whether the board would like to meet with representative from the AGO. Why do they get to pick and choose? Do you see this going on with any other school or institution? This is insane. The level of control and the amount of rope these people give the JRC is just mind-blowing. Mind-blowing. The board shall have an opportunity to present facts and evidence to support their decision not to adopt a certain recommendation of the monitor, and this must be completed within 2 months of the issuance of the report. Then tell me, why did you even do one at all? If they can actually choose to not implement anything you recommend to stop events like this, why was it even done? Within 1 month of the board's vote, JRC will implement all changes approved by the board. When JRC notifies the monitor that all changes have been implemented, the monitor will begin 3 quarterly reviews of changes. The monitor's quarterly reports are due 1 month after the end of a quarter. The 127 pages of this report do not adequately reflect the amount of work that the monitor and 2 attorneys working closely with them dedicated to the task at hand. Thousands of hours were spent interviewing individuals, reading reports and other documents, and learning everything possibly related to the mandate for the monitor. Oh, but not about the treatment of the students themselves. God, how can you be there and witness what is happening to them and just not care? I don't understand. What kind of horrible human being do you have to be to observe all of this happening and not care? All JRC staff and administrators were extremely cooperative and supplied all relevant information as requested by the monitor and his team. Of course they were. As long as you're not actually investigating them, just investigating an incident that they can lie their way out of course they'll give you whatever you want. Documents reviewed, JRC policy and procedure documents. DVR Operating Manual, revised July 20th, 2011. Basic Training Manual, revised June 29th, 2011. Yeah, we'll go past this here. So this is all the documents that they reviewed. Again, you will find the attachment to this in the uh, in the description box. Okay, let's read this little excerpt here. Current JRC staff, students, and parents. 7 mental health assistants, 2 high crisis specialists, 1 workshop coordinator, 3 residential supervisors, 1 weekend supervisor, 3 special education teachers, and JRC's security consultant off-duty state trooper were interviewed. Judge Bernstein attended a portion of a parent association meeting at JRC on October 29, 2011. 7 parents, guardians of the JRC clients, and 2 students currently on GED were also interviewed. Oh, yes, let's get the parents' opinions that subjected their kids to this. Quality control monitor assigned to monitor the Stoughton residents. Letters were sent to former staff members requesting interviews. However, all letters were returned because the addressees were no longer current and the post office did not have a forwarding address. Similar letters were sent to former staff members, however, no response or returned envelope was received. John Doe, one of the students who received the inappropriate GEDs, was interviewed for this report. JRC could not provide current address for the other students involved. James Rowe, Mark Poe, and Paul No, all of whom were discharged from JRC in 2007, soon after the incident. Well, isn't that convenient? Okay, now they list state agencies and nonprofit organizations. Oh, God. Well, folks, I'm going to go ahead and close it out because that one's going to be a rant and a half. I can just feel it. But what I'm taking from this, what I find really interesting, is this judge that came in order to do monitoring in regards to this incident, was very carefully directed to not at all look into the use of the GEDs in and of themselves. Not only that, but he was being paid for his services by the folks that are under investigation. I want to know how on earth, is that allowed? And not only is he getting paid by the JRC by the state was given enough authority to declare whether or not they would take me to the recommendations of that said retired judge. How does this make any comprehensive sense? It would make more sense to put someone in there who with no biased opinion one way or the other. And why won't Massachusetts let somebody come in there from the state and actually do a full-scale investigation in regards to the treatment the students receive there? If everything they do, like they say, is above board, what are they so afraid of? Just saying. And with that, I will go ahead and close out for this morning. Now, folks, we don't get very many views on this channel. The few that we do tend to get removed from time to time. So, folks, please don't forget to hit that like button, hit subscribe, don't forget to hit the comments. I do appreciate your time this morning. And as always, we here at Spilling Tea hope you have a good one. Bye-bye.